Hey, Fidelity. Can I get a second opinion on stocks in the Fidelity app?
With Fidelity, it's easy to get an outside opinion from independent experts in a single score.
And then?
When you're ready, trade U.S. stocks and ETFs with no commissions.
That's right.
I am always right.
Investing involves risk, including risk of loss. $0 commission does not apply to customers designated by Fidelity as a professional equity trader. A limited number of ETFs are subject to a service fee of $100. See details at fidelity.com/commissions. Fidelity Brokerage Services, LLC, member NYSE SIPC.
Adobe Firefly is the all-in-one creative studio with AI-powered image and video editing for today's creative process. Built for creators of every kind, Firefly helps you generate, edit, and experiment fast. Because the asks aren't getting smaller, the budgets aren't getting bigger, and the timelines, oh yeah, still tight. With all the best creative AI models in one place, Firefly brings your ideas to life. Unlock a better way to make with Adobe Firefly.
Atheists, agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government, love.
Welcome to the Politics Guys. I'm political scientist Michael Baranowski, an emeritus professor at Northern Kentucky University. My guest today is Thomas Berry, the director of the Cato Institute's Robert A. Levy Center for Constitutional Studies and editor-in-chief of the Cato Supreme Court Review. Before joining Cato, he was an attorney at the Pacific Legal Foundation and clerked for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. Thomas Berry, welcome to the show.
Thank you. Thanks for inviting me.
So I thought I'd start with Cato itself and its approach to the Supreme Court. What would you say is distinctive about how Cato approaches Supreme Court litigation commentary, say compared with groups like the Federal Society on the right or, say, the American Constitution Society on the left?
Sure. So for decades, debate about constitutional interpretation was often summed up into two competing sides, so-called judicial activism or judicial progressivism versus judicial restraint or judicial conservatism. So much of constitutional commentary was defined by the Warren Court and to some extent the follow-up Burger Court of the 1960s through 70s and the backlash against it. And people thought that those were the only two approaches to constitutional law. There was the aggressive, muscular progressivism of Earl Warren and Justice Brennan that found a lot of individual rights in the Constitution, both criminal justice procedural rights, as well as probably most controversially reproductive rights. And then there were the judicial restraint folks on the right, the Warren Burgers and such, William Rehnquists, who kind of defined themselves as saying, we're going to take a more restrained approach. We're not going to strike down acts of democratically elected legislatures unless we think there's absolutely no other choice and that it's not the role of judges to be policymakers. So Cato Center for Constitutional Studies was founded in 1909 by Roger Pilon, and it really adopted a third way between the two that we like to call judicial engagement, which says some of the critiques of both sides are correct. Yes, judicial progressives too often did constitutional law not based on the actual text and history of the Constitution, but based on policy preferences. But the backlash was an overreaction. Conservatives veered too much in the direction of thinking there's no such thing as constitutional rights, or the Constitution doesn't protect that many individual rights, or especially we were opposed to the conservative idea that the Constitution does not protect so-called unenumerated rights. So our approach says that, in fact, an honest, good faith approach to the history of the Constitution and the meaning of some of its terms, like the Ninth Amendment and the 14th Amendment Privileges or Immunities Clause, shows that there were not spelled out, but understood individual rights like the right to earn the living, the right to choose how you form a family, those types of things that judges can and should enforce if they're faithful agents of the Constitution. And so what we say is that a judge should not have his thumb on the scale either against nor in favor of upholding any given statute. They should simply engage with the constitutional text honestly without any kind of bias in either direction. And often that does mean standing up against the political branches.
You know, when I read most mainstream media coverage of Supreme Court decisions, it feels to me more than anything else like sort of an ideological scorekeeping endeavor. You know, conservatives won, liberals lost, Democrats, Republicans, that sort of thing. And I'm wondering, what do you think, if anything, is most misleading or lost with that sort of a framing or reading of the court in those kind of way.
Yeah, it can be misleading many times over and for many different reasons. So one of the most basic is it can be misleading about what was the court actually deciding and at what stage is the litigation. We saw this over and over again last year in calendar year 2025 when on the so-called shadow docket or emergency docket, the Supreme Court would give the Trump administration temporary wins. They would say this lawsuit was filed in the wrong court, or this plaintiff doesn't have standing to sue, you need to find someone else. Those types of temporary wins, not ruling on the merits, not ruling on the constitutional question, but the headlines would always just be Trump administration wins. We saw these types of headlines, for example, in the birthright citizenship case when it went up to the Supreme Court last year, not on the merits of does the Constitution protect birthright citizenship, but on a procedural question, an important one, but still procedural. Can a judge issue a nationwide injunction just from a single district court that affects the entire country? But again, so many of the headlines of that case simply said Trump wins in birthright citizenship case. So often the headlines miss the nuance of what were they deciding? Was it on the merits or not? And also what implications could this procedural decision have for the opposite side? Ending nationwide injunctions is going to have just as much of a significant effect on conservative litigators the next time there's a Democratic president. Yeah. The second thing it misses is that it blurs the lines between policy agreement and disagreement versus legal agreement and disagreement. When you had headlines about Trump loses on tariffs or Supreme Court opposes Trump on tariffs, that doesn't mean we had 6 justices who wrote an opinion saying, here's why tariffs are bad for the economy. The decisions the court makes are based on legal grounds. Was this authorized by the text of a statute? Is this compatible with the Constitution? But often the layperson will assume, oh, well, there are 6 conservative justices and they like conservative policies, so they vote to uphold conservative policies. But if you look at the court, that's simply not true. Justice Thomas had an opinion a couple terms ago rejecting a challenge to the CFPB, the Consumer Financial Protection Bureau, and the way it's funded, the way it's appropriated. I doubt Justice Thomas is much of a fan of the CFPB on policy grounds, but it didn't matter. He just didn't buy the challenge as a constitutional matter. And the press just never really focuses on those examples that we see all the time where justices vote against their personal policy views.
That's one of the things that more than anything else disturbs me, I guess, about so much of coverage of the court is there's this almost implicit view, at least from some people, that bad policy must equal unconstitutional and vice versa. I wonder, do you have any thoughts as to why that frame is so common?
I mean, several reasons. So Justice Scalia, had a legitimate criticism, which was that the less grounded a constitutional theory is, the more wiggle room there is to just go with what's reasonable, or the more a justice might just pick and choose the history he likes, the more likely a justice is to assume that the people who drafted a statute or a constitution thought like that justice. And so absolutely there is motivated reasoning. I don't think justices are overtly policy-oriented or overtly in bad faith, but absolutely there can be motivated reasoning the less of a sort of ironclad approach they have to try to bind themselves by non-policy-based things. And so certainly you tend to see progressive justices have a view, are more sympathetic towards, the more progressive voices in the legislative history, for example, or the more progressive interpretations or ways of looking at a statute. And basically the only solution to that is to have a judicial philosophy that's ironclad and where you lay out your method of decision-making in advance and people can check your work.
Yeah, I wanted to talk to you about that. So, when you approach the Constitution, would you say you do so more from an originalist, textualist? I'm guessing probably not libertarian constitutionalist, something else, some combination. Maybe you could talk a little bit about how you approach that and why you think that's the preferred way or the better way to go about it.
Sure. So I consider myself both an originalist and a textualist. I think those two concepts are very similar. Textualist is usually used when we're talking about statutes, and originalist is usually used when we're talking about the Constitution. Really, the biggest difference, though, between the two is just that the Constitution is a lot older. So when you're interpreting the Constitution, you have to deal more with the problem of so-called linguistic drift, which we don't have as often if you're interpreting a statute that's, say, passed in the last 100 years, certainly in the last 50 years. So just one example of linguistic drift, this is an easy one. There's a provision of the Constitution that says that governors can ask the federal government for help to deal with domestic violence. Today, domestic violence typically refers to violence within the home, within the family. At that time, 250 years ago, it basically referred to insurrections or mobs. So that's an example where linguistic drift means that if we were just being textualist and cracking open a 2026 dictionary, we might misinterpret that clause of the Constitution. So originalism emphasizes the fact that you have to look at what the text meant on the day it was adopted to an educated, normal speaker of English, not on the day that you're interpreting it. And that's true of textualism as well. It just doesn't as often lead to different answers in textualism if you're interpreting, the 1965 Civil Rights Act or Voting Rights Act. Language hasn't changed as much from the 1960s as it has from the 1780s. So, but where that differs is that, when you ask, am I a libertarian interpreter of the Constitution, the evolution of law professor Randy Barnett is a great example of this. And he writes very eloquently about how he shifted. Early on in his career, he was what he described as a libertarian Dworkinian after Ronald Dworkin. And Dworkin was a progressive, and he was probably the most forthright advocate of the view that most legal answers are indeterminate, and a judge should simply, within the bounds of reasonable interpretation, go with the one that makes the Constitution the best from that judge's point of view, including their progressive politics. And so, as Barnett said, he was a libertarian politically, and so you could just as easily adopt that for any. If you're a libertarian, you could say, I don't care what the original meaning was. A lot of this is indeterminate. I'm just going to interpret the Constitution in the most libertarian outcome way possible that doesn't cross the lines of just out and out bad faith or out and out ignoring ironclad text. But where Barnett eventually shifted to originalism was, and I think the correct discovery, which was actually the text is more determinate than people give it credit for. So I think people who are originalists and textualists are people who agree with the view that actually we can look at nothing but the original public meaning of a text and get the answer just from that. We don't have to add on our policy views or add on concerns about what the consequences of a ruling will be. And today, really, the big split is between textualists and originalists versus pluralists. That's how most progressive jurists would self-describe. And so it's a misconception, or, it's a straw man to say that jurists on the left don't care about text or history. They do. They just don't stop there. If the text is hard, if it's not obvious what the answer is, they might then go to principles or consequences or things like that. Whereas an originalist and a textualist says, no, you have to stop there. You can't add on concerns about outcomes, concerns about fairness, that type of thing. Now, that being said, I think the best reading of the history is that in many, not in all ways, but in many ways, the Constitution is a libertarian document. If you look at the Federalist Papers and the Constitutional Convention, they were most concerned with all of the ways that England at the time was crushing our rights, our individual rights, and blurring the separation of powers. And so more than most constitutions, ours is very laser focused on those two concerns, protecting individual rights against majorities and protecting each of the three branches against encroachment by the other two. So in my view, an originalist and a textualist approach to the Constitution will often lead to smaller government and more protection for individual rights, but certainly not 100% of the time. If it did 100% of the time, I would be, as outcome oriented as the people I'm criticizing.
One common critique on the left about originalism is, well, really, there's this fake neutrality about it. It's actually, in many instances, results-oriented, kind of dressed up as a neutral method. And so we'll see conservative justices using it, picking and choosing various words out of context, what have you, when it gets them kind of where they want to go, but then moving away from it when it doesn't so much. And I'm wondering to what extent you think that critique is at all fair or reasonable.
I think to the extent there's an element of truth to it, less so now. Maybe a decade ago, certainly 2 decades ago, really only conservative lawyers and law professors were making originalist arguments. And listeners have to always remember the court doesn't do its own research, really. No, the Supreme Court doesn't, lower courts don't. We have an adversarial system where they basically deal with the evidence in the history that's been presented to them. So for a while, judges and Supreme Court justices were really only getting deep dives into the history from one side, from the conservative side. And so to that extent, conservatives too often, and libertarians had a bit of a monopoly on making originalist cases for their point of view. That is, I think, no longer true. I think you can look to the birthright citizenship oral argument as a great example recently, where you had both sides doing very deep dives into the history and fully engaging on the originalist approach. And now both sides of the court have quite a lot of originalist argumentation at their disposal, and it's no longer the case that originalist arguments are only being made by those who are trying to get conservative or libertarian outcomes. And you can see a lot of recent examples where originalists on the court have voted not for the so-called conservative outcome. Look at the Rahimi case just recently, applying the Bruin standard to a Second Amendment case, rejected 8-1. A pro-gun challenge, a challenge to a restriction on gun ownership by people who have restraining orders against them, applying text and history, looking at the original meaning and the state of gun laws at the time of the founding. They said, yes, this fits into one of the restrictions on guns at the time of the founding. So it's just not true that the originalists will, always vote to strike down a gun restriction or always vote against an administrative agency. Again, the CFPB case I mentioned is a good example. Another one, a challenge to the FCC recently on non-delegation doctrine. Again, that challenge failed as well with several originalists in the majority.
A lot of conservatives will say what the current court is doing with the Roberts Court, the project of the Roberts Court in part, has been restoring the Constitution after really generations of what they might call liberal judicial overreach. Now, critics on the left, will say, actually, what we're seeing is actually just a different kind of judicial activism, conservative judicial activism. And so I'm wondering, how do you think about that line sort of between correcting what conservatives might see as past constitutional errors, but not overstepping and substituting one sort of activism for another?
Right. I mean, this is one of the big debates, I think, at the court right now, which is also framed as the role of stare decisis, a Latin term for the decision should stand, which is the idea that even if a decision was wrong, there are reliance interests. There are interests in stability and predictability that the court generally values simply leaving each decision in place and building off of it rather than going back and correcting it. Now, there are competing doctrines which say, for example, that stare decisis should be less of a force when interpreting the Constitution, because if they make a mistake, it's harder for the people to correct that mistake. It's much harder to amend the Constitution than it is, say, to amend a statute if the Supreme Court misinterprets a statute. So they have the notion that if we egregiously misinterpret a statute, Congress will fix it, and that if Congress doesn't fix it, they sort of implicitly accepted our interpretation. I think maybe even that goes too far, but the court tends to take that approach. Now, obviously, we've had a lot of decisions recently overturning very significant precedents. The Dobbs overturning Roe v. Wade, the most high profile, that was a constitutional case, and a lot of the opinion by Justice Alito when discussing stare decisis focused on that fact, that it's a constitutional case and that there is no way for the states or federal government to overrule it. But also, for example, ending Chevron deference. That was a foundational decision of administrative law for 40 years. So overturning that is a very big deal. But you could argue really more just forward-looking effects rather than upsetting past-looking rights. Yeah. My own view is that I tend to put less weight on stare decisis than others, and I think, to be honest, this current court puts less weight on it because they view so many of these precedents as decided from just wrong first principles. So if the Supreme Court of the 50s, 60s, and 70s had been self-described originalists and had done originalism the way the current court does, but had reached decisions this current court disagrees with, I think this current court would be less inclined to overrule those decisions. But because that court took an entirely different approach, I think the court now is more inclined to see, well, we're not just disagreeing with them on application, we're fixing a fundamental misunderstanding about how we should do our jobs. So a very recent decision in the Louisiana redistricting case, there's a line about an old precedent called Jingles or Gingles that says it was decided at a time when this court paid less attention to the statutory text than we do today. And that's kind of Alito's way of setting up the fact that we don't feel as concerned about adjusting this precedent or partially overruling it as we might if it were a fully textualist precedent.
In business, the best days are when priorities stay on track. For midsize and large companies, that means managing multiple exposures, from property and liability to cyber and more. The Hartford helps companies plan for risk with insurance and proactive risk solutions, so focus can stay where it belongs. Prepare for risk. Protect success. Smart risk management from The Hartford. Contact your agent or visit thehartford.com/risk mitigation.
From hidden Mediterranean gems to the wilderness of Antarctica, Silversea invites you to explore the world in greater depth. Venture to over 900 destinations across all 7 continents. On board small ships that set the standard for elite ocean travel. Every journey opens doors to extraordinary discoveries. And wherever you sail, you can expect the same Silversea promise. Unrivaled service, unmatched comfort, and unforgettable memories. Visit silversea.com to learn more.
You know, when I think about stare decisis and how the justices sort of approach that, at least especially when I think about the conservative majority, I feel like on the one pole, we have the chief who I feel like Chief Justice Roberts is sort of a institutionalist, kind of is maybe the least reluctant of the court's conservatives to really just drop precedent. And then on the other hand, there's Justice Thomas, who I feel there's almost this almost kind of commendable, even if I disagree with him, purity where he's, I mean, like you mentioned in the Calais decision, just basically saying, well, you know what? I just don't think Section 2 of the VRA has anything to do with redistricting. Let's just get rid of this test entirely and all this. And I guess, would you say that's a reasonable take, or am I off base here? What do you think?
Very much so. I was actually just at a book event for Sarah Isger's new book, Last Branch Standing. Excellent book, and she rates the justices on 2 axes, not just one. There's ideology, which everyone sort of focuses on, but there's this other axis you've identified, institutionalist versus what she calls YOLO, or just, what you described. I'm going to say exactly what I think, and I don't care as much about stare decisis or about consequences. So I'd also rate Justice Gorsuch, who I believe just joined Justice Thomas in that opinion you mentioned. A classic example is Justice Gorsuch's vote in the McGirt case, which resulted in half of Oklahoma being found to be essentially an Indian reservation in which state criminal law did not apply. That had a lot of people thought the Supreme Court would never go that far because the consequences would upset the apple cart so much. Justice Gorsuch really doesn't put any weight on how much a decision is going to upset the apple cart. He's just going to call it as he sees it, whereas I would put Chief Justice Roberts, Justice Kavanaugh, and probably Justice Kagan as well in the institutionalist camp, as you mentioned, which means both they put more weight on stare decisis and they're more willing to try to get consensus or try to compromise to get a majority rather than write a solo concurrence or a solo dissent. You don't see it. I think it took a decade before Chief Justice Roberts wrote his first solo dissent on the court. He very, very rarely does it. Justice Kagan as well very rarely does solo dissents. She tries to get all the dissenters to sign on to her opinions, whereas Justice Jackson, she seems to be on the left, the closest of the YOLO. She has written many. I think she wrote 3 solo dissents just in her first term. And so like Gorsuch and Thomas on the right, she's really saying, I'm going to tell you exactly what my unique approach to constitutional interpretation is. I don't care if none of the other 8 justices buy it now. I'm writing for the future.
And I feel like there's a real value in that. When I read, especially Justice Thomas's concurrences or dissents, even if I don't agree, I feel like there's a role in sort of keeping the conservatives honest and admitting in a way, even if indirectly, that, hey, they're kind of bowing to political realities, if you will. And the same thing you can say on the left. But on the other hand, I wouldn't want a court made up entirely of YOLO conservatives or liberals, because I think that would be disastrous. And I'm wondering how you kind of weigh the value of those viewpoints on the court as opposed to, should the court be considering political and logistical realities in some instances? What do you think?
Yeah, well, I think there's two questions there. One is the difference in approach to getting majorities versus just being a purist. And I think there having a mix is important. So if everyone was as much of a purist as a Thomas or a Gorsuch, it would be a lot harder to cobble together majorities. You'd have a lot more non-presidential opinions where you have 5 justices who concur in the judgment, but maybe all of them write an opinion a different way, and you don't get any consensus. So if every justice were as much of a stickler about joining text that maybe they don't 100% agree with, it would be hard for the court to do its job of writing a single majority opinion that lets people know this is the law going forward. It's funny, at the earliest days of the Supreme Court, we had a practice of seriatim opinions where there was no single majority opinion for the court. Every justice wrote a short explanation of why he voted one way or the other, and it was the great Chief Justice John Marshall who ended that and said, no, our opinions will have more weight, our decisions will have more weight if there is a single opinion for the court, and I'm going to write it 99% of the time. And that tradition, it shows, I think, the force of that tradition has stuck ever since. The second axis is thinking about consequences versus not. There, as a textualist and originalist, I'm more in the Gorsuch camp of that's something that should not be thrown in unless you can make a good case that consequences are part of the actual text, that the text itself that you're interpreting tells you to take into account consequences. And there might be cases where that's true. So in administrative law, there's a doctrine that you can't an administrative action should stand unless it's basically so unreasonable that it's such a bad policy judgment that courts shouldn't be allowed to let it stand. So that's one where consequences might come into it. But if you're just interpreting a treaty, as he was in the McGirt case, then no, a treaty is binding. Sometimes the point of a binding agreement is that both sides take a certain risk that they might end up being losers of the contract or the treaty, that it might end up being a benefit more to one or the other. But the point is that it's binding and you have to enforce it no matter what. If you let people get out of a contract or get out of a treaty because it turned out the consequences for one were really bad, then people wouldn't really be able to bargain and wouldn't really be able to rely on those being ironclad. So I think a lot of constitutional rights work that way as well. Individual rights like freedom of speech, so often the argument from the other side, the argument from the government trying to defend a law will be, well, this is really necessary. It would be disastrous if we can't just infringe on speech a little bit here. But I think constitutional rights are better protected if justices say, no, the point of these constitutional rights is that we took them out of democratic debate. We took them out of the normal policymaking balancing test because we're just too concerned about majorities suppressing majority for the sake of what seems like better consequences at one given moment.
On a recent case, the recent tariffs case, Cato actually sided against the Trump administration. But after that ruling came down, the Trump administration basically said, not a problem, we'll just look for other ways to do this. It reminded me a lot of the Biden administration and student loan forgiveness, what they did when the Supreme Court said that initially their approach they couldn't work, said, well, we'll find another way. And I'm wondering, do you get a sense that presidents particularly have become more aggressive, brazen, choose your word, in basically saying, well, the Supreme Court has ruled, not necessarily let them try to enforce it, but hey, we'll find a way around that. Do you think that's more of the thing today? And if so, do you think it's problematic at all?
It's definitely more of a thing, though it is important to draw a distinction. There are two ways in which you can sort of defy the Supreme Court. So one, the let them enforce it might be apocryphal, but supposedly Justice Jackson said this. The Supreme Court has made its decision, now let them enforce it. Out and out defiance of an actual judgment of the Supreme Court. Fortunately, we have not seen that from presidents. Even this President Trump, who I think has come close to the line, his administration at the district court level has come close to the line of defying court orders, but it's still an important line that they have not out and out admitted that they are flouting them. We have seen a trend, I think the trend, though, of saying, okay, you struck me down on this statute, let me fight find another one. That's connected to a bigger trend we've seen, which is presidents of both parties, rather than having a policy goal, coming into office with a policy priority, not being able to get Congress to give them the statute they want, which is how the system is supposed to work, and therefore just going hunting for any old statute that they can find that they can make a halfway plausible argument. This policy power was actually hiding in this old statute the whole time. So that's what Biden did in the student loans case with this law called the HEROES Act from the Iraq War era that was totally uncontroversial at the time it was passed. And that's what Trump did with tariffs with IEEPA, a statute from about 50 years ago that had never before been used to enact tariffs. And so once presidents have that attitude of, I'm just going to go hunting for an old statute to enact a new policy, then it's totally natural for them to say, okay, you stopped this statute, let me find another old statute. And indeed, that's exactly what Trump has done. He's now trying to use Section 122 of a trade statute from the 1970s that pretty clearly was just aimed at monetary concerns, monetary policy imbalances from the old gold standard. And now he's trying to say that it's applicable today to fight so-called trade imbalances. It's unfortunate, but again, I don't think it means that the Supreme Court's decisions don't matter because there's litigation over the new statute. We've already filed an amicus brief in litigation over this Section 122 statute. There's not an infinite number of statutes that the president can find, and the courts have the capacity to strike down all of them if they're all just as implausible. And doctrines like the major questions doctrine are an important check, or an important realization by the courts that this is increasingly happening, and it's kind of a doctrine encapsulating the, come on, man, that's just not plausible that this was hiding in plain sight for 50 years.
I mentioned already Cato opposed the Trump administration on tariffs, also on birthright citizenship, but Cato supported the administration in Trump versus Slaughter, and that issue is whether the president has more power to remove officials from independent agencies, like, for instance, like the FTC. And I think some people might see that and say, well, wait a second. So in one instance, you say less executive power, less deference to the executive, but in this instance, more deference and more executive power. How do you kind of reconcile those positions?
Yep, it's a good question, and it's a question we get a lot. In a nutshell, some of those cases are about the balance of power between the executive branch as a whole versus the other two branches, the executive versus the legislative in the tariffs case, or the executive versus the judicial in the Chevron case, whereas Slaughter is about intra-executive branch power. It's not about the balance of power of the entire executive branch versus one of the other two branches. It's about intra-executive branch power, the president's power versus the power of other people nominally below the president, exercising the powers of the executive branch, but not necessarily under the direct control of the president. So in a nutshell, we think that the executive branch as an entity has way too much power at the expense of the other two branches, has way too much power at the expense of the states, and probably should be about 10% of the size that it is. But however big and however powerful, or however small and however not powerful the executive branch as a whole should be, my view is that it should be entirely under the control of the elected president, that the best interpretation of the structure of our federal constitution is that all executive power is vested in a president of the United States. He is the only one who's elected other than the vice president, but the vice president doesn't get any executive power unless and until he has to replace the president. So none of the other cabinet members are elected. None of the heads of the so-called independent agencies are elected. It's just the president. That's the only democratically legitimate answer for why the executive branch can make policy and choose to enforce the laws one way or the other. That's not the only way you could make an executive branch. Most states do not have unitary executives. I live in Virginia, where the attorney general is elected separately. So sometimes we have a Republican governor and a Democratic attorney general, or vice versa. Some states have 5 different cabinet members, all elected separately, and they can be a whole hodgepodge of competing policy priorities. But that's still democratically legitimate because they're each elected. But in our federal system, we don't have that. We only have one elected president. And so the problem with an independent agency like the FTC, FCC, SEC, et cetera, is that some of the appointees from prior presidents are kept in office, are not allowed to be removed by the current president because of policy differences, and as a result could either make decisions that the current president disagrees with Or, more likely and more plausibly, the current president can avoid accountability for their decisions. He can say, look, don't blame me for whatever they're deciding. I can't fire them even if I did disagree with them. So as much as I dislike a lot of the stuff that's coming out of this FCC, for example, I would much rather have a system where President Trump has to own everything it's doing.
I've changed a lot on this issue because I remember back in the Bush administration, George W. Bush reading some of the John Yoo articles, memos, and just thinking, this guy's a nut with this whole crazy, wild unitary executive thing. But I've become sort of a reluctant convert to it. I say reluctant because I am very nervous about dramatically increasing presidential power during an administration that seems hell-bent on using its power against political enemies. And I'm wondering, do you think it's reasonable for judges to take that kind of real-world context into account, or is that just not their job?
Right. Well, I certainly understand the sentiment, and people will ask, why now? Why is the Supreme Court doing this now? One thing you have to remember, again, is that the Supreme Court doesn't get to decide what cases are teed up for it. Cases are teed up by private litigants or the political actors. And for better or worse, this Trump administration, this DOJ, is the first one to put its money where its mouth is and tee up a case directly challenging protections for the so-called independent agencies. The Bush administration could have done that, but they chose not to. President Trump fired several members of independent agencies and simply said, I'm doing this because of policy disagreements, knowing that it would directly tee up this question of should Humphrey's executor, the decision that blessed independent agencies, should that decision be overruled? So this is not the Supreme Court, and this is another example where reporting often misses this. The Supreme Court liked the unitary executive under Biden. Now it doesn't like the unitary executive. No, it's that Biden never directly teed up a challenge to the unitary executive. If he had, it very likely would have gone up to the Supreme Court and we would have had a decision on this issue 4 years ago. Certainly, I understand the concerns about, and I agree with much of the criticism of this current administration and the various ways in which it's abused authority and used the powers of government to attack its enemies and support its friends. But I would say that relying on independent agencies was always a shaky foundation to protect us from the president. It was never really going to hold for a lot of reasons, one of which is the soft power, the soft influence of independent agencies, which I think is the worst of both worlds. You can have a president making policies but avoid accountability for them. But the other is that it took too much heat off of the other branches, which are the ones supposed to be checking the executive branch. So what's the answer to politicized prosecutions? It's independent, informed grand juries refusing to indict people. It's judges not giving the executive branch the so-called presumption of regularity, the assumption that the executive branch is telling the truth. It's judges more strictly enforcing the text of statutes so that the administration can't bend or push them to enact whatever policy it wants. It's Congress writing statutes with less wiggle room and less policymaking discretion for the executive so that the FCC can't use broad-based policy grounds to go after the late-night hosts it doesn't like and shut down their particular stations. So there are all sorts of ways in which I hope if the court does strike down Humphrey's executor, the other two branches will realize, wow, if it wasn't already, it's time for us to pick up the slack.
So in a sense, the court has been kind of almost in a codependent relationship with Congress, enabling it to be lazy and not write good legislation. And this is maybe, at least from a more conservative, originalist kind of perspective, a corrective to that.
I think so, yes. I think they're connected. At Cato, we're fans of hopefully someday reviving the non-delegation doctrine, the idea that a statute can be so vague that it's unconstitutional because it basically delegates the legislative power to the executive branch. That's a long-term project. I'm not sure that that's going to succeed soon. But the stricter interpretation of statutes, the major questions doctrine, the end of Chevron, those are all pointing in the right direction, where we're already in a situation where the executive branch cannot fill statutes with any policy it wants to the extent that it could even 5 or 10 years ago.
I think the issue of the Fed really kind of brings this out in an interesting way, because when I've read what the court has sort of hinted at about the independence of the Fed, I gotta say, it seems like kind of a reach. It's like, well, yes, we believe in the unitary executive, at least the court's conservatives, but the Fed is different, and I gotta say, it doesn't feel very convincing to me. It feels more like, well, we just don't want presidents messing with the Fed because it's too important. I'm wondering what you think about that.
Yeah, I agree. And this is an example where, as a think tanker, as an amicus, it's a lot easier to be on the YOLO side of the consequences versus as a judge or a justice. It feels like Justice Kavanaugh is the one really pushing for this exception for the Fed, probably Chief Justice Roberts itself as well. And their votes are necessary to win any of these cases. So if they want to carve out an exception for the Fed, that's going to have to be how it's written. I'm curious to see how the more, not principled, but the less willing to compromise justices like Gorsuch or Thomas, I'm curious to see whether they agree with that type of carve out. I think, again, here's how I would put it. If you think it would be disastrous for the elected president to have direct control over any federal agency, that's a sign that that federal agency has too much unbounded discretion. So my answer would be write a statute with so much specificity that the Fed is basically reduced to just applying an algorithm and doesn't have as much unbounded discretion as it does now. Maybe Congress only wrote statutes the way they did because they were hopeful and expectant that the agency would be led by unbiased apolitical wonks. But that's just not how our system goes. Congress are the ones who are supposed to be wonks. And so maybe this will force them to go back to the drawing board and rethink how much discretion they've given the Fed.
Now, in the past, you've written that even with the court being more skeptical of government power, at least in some areas, that the government still knows how to win at the Supreme Court. And I'm wondering if you could talk about what you see as the government's kind of built-in advantages before the court.
Yeah, they have several. So there's the presumption of regularity, which I mentioned, which is basically this idea that the DOJ, when they're a litigant, that we assume they're acting in good faith. We assume the representations they make are accurate. We assume that they have the interest of not just winning their case, but the interest of justice uniquely compared to private litigants. And I think recent examples, at least under the Trump administration, have shown that they don't deserve that presumption anymore. We've seen lots of examples where either through incompetence or oversight or just out and out misrepresentation, they've misled courts in many instances or not given a full picture of the truth, sometimes having to file embarrassing filings after the fact explaining all the ways in which they misled the court or did not give a full picture of the truth. So you have the presumption of regularity. You also have the doctrine of constitutional avoidance, which I'm not a huge fan of. So very often people will challenge a statute, basically say this is unconstitutional either because it violates individual rights or it exceeds the power of the executive, it violates the non-delegation doctrine. And what judges and justices over and over choose to do, what the doctrine of constitutional avoidance says, is if there's any way we can finesse this language to turn it into a statute that's okay, we should do that before taking the drastic step of striking it down. So they've done that in several. They did that with regards to a statute about encouraging people to violate immigration law. There was a First Amendment challenge to that. We've seen it in terms of that CFPB statute I mentioned. We saw it in an appointments clause case recently where there is a question about whether people who are not confirmed by the Senate had too much independent judgment. All sorts of cases where I think the Supreme Court has not read this text in the most plain meaning, has not actually been pure textualists, but has put a thumb on the scale in favor of the meaning that shrinks the power just enough to get across that line to be constitutional. And then they uphold the new statute as defined. And you might say, well, what's the problem? They shrunk the statute a little bit, so now it's within good bounds. Two big problems for me. One is that up until they did that, the government would always interpret it maximally. So again, this case about punishing people for encouraging immigration violations is a great example. Prosecutors would always threaten people with huge charges, would take the most maximalist view of what it applies to, that just basically any advocate, telling your housekeeper, I really wish you'd stay another 6 months instead of going back home to live with your grandmother in the country you came from, they would say that could potentially be, criminally prosecutable. Only when it's on its last legs and under threat at the Supreme Court do they change their tune. That doesn't go back and save all the people that they coerced back when they took the maximalist approach to it. I think it seems like the court might be doing that in a case right now about about enforcement actions from the FCC, where the FCC sends people a scary letter saying you've been found in violation of FCC regulations, you owe us $50 million. They would send this without a jury. Now at the Supreme Court, they're saying, oh, that letter means nothing. You can just ignore it. And if we have to come collect the $50 million, then you get a jury. And it seemed like some of the justices were actually willing to buy that. Again, interpreting it in a narrower way to save it. That doesn't fix the problem of how for decades everyone coughed up the money without a jury because of these scary letters. Right. So for me, that's one of the biggest ones. Constitutional avoidance might seem like judicial restraint, but in the long run, it's just become a government get-out-of-jail-free card.
This administration in particular has used threats of removing federal funding to pressure, say, universities, other institutions into various policy concessions. And I know there's some previous Supreme Court cases that speak to this, but when does, in your view, government funding become unconstitutional government coercion? I mean, is there some sort of a bright line test, or at least is some sort of a general guideline on this?
I wish. Unfortunately, there's not. I mean, what comes to mind is the language from Chief Justice Roberts' opinion in the Obamacare case, NFIB versus Sebelius. Everyone remembers the Obamacare part of that, or the individual mandate part. Less people remember the Medicare and Medicaid subsidies part, where there was a trigger that would have removed basically all funding from states, basically would have devastated their healthcare systems, their state-run healthcare systems. And Chief Justice Roberts said that this was equivalent to a gun to the head, and that this violated federalism principles because it wasn't really a choice. The punishment was so extreme that no state could, in reality, had the option to turn it down. So there's one rough and ready question: is this a real choice, or is it a gun to the head? In other words, you could look at empirically: is this something that is this a deal? To use mob parlance, is this an offer they can't refuse, or is this an offer that some do refuse? That might be an example. As a libertarian, it's just an example to me of the problems you run into when you start going down the path of making private institutions so entangled with government and so reliant on government funding. It puts them in this position now where eliminating every government grant or every government benefit would so upset their business model that it might be an existential risk to them. To me, though, it doesn't even have to cross that line if the punishment is for certain bad reasons. And First Amendment, I think, here is the best example, and is probably why, in fact, the Trump administration has threatened so many of these universities. And there we have much more muscular doctrine of retaliation, both job owning before the fact, which is basically you can't threaten people with potential punishment if they say something, and then retaliation after the fact, which is they did say something and now you are in fact punishing them in some certain way, retaliating against them. And there, it doesn't have to be an existential threat. It doesn't have to be you took away all their funding. Any form of retaliation, any form of punishment is too much if it's because of exercising First Amendment rights. And to me, that's the easy answer for why these law firm executive orders, as well as the university executive orders and many others, are unconstitutional.
Some people might say, well, okay, you talked about the Sebelius decision, and there was an earlier decision relating to highway funds and the drinking age. Some would say that that's different than what we're seeing with, say, Trump and the universities, because in those cases, it was the federal government and states occupy a different position vis-a-vis the federal government because they're sort of semi-sovereign entities, whereas private institutions aren't and have a different kind of status. Do you think there's anything to that argument?
Yeah, it's certainly different questions. So at the highway case you mentioned is a great example. I think that was wrongly decided. Basically, the federal government coerced every single state to raise its drinking age to 21 because they said, if you don't, we'll deny you all federal highway funds. Again, the fact that all 50 states took that deal is a suggestion that it wasn't really a genuine offer, genuine bargain at all. It was something that they had no choice but to accept. And the problem there is one of federalism, that most policy decisions in our federalist system were designed to be made at the state level, not at the federal level. And to the extent that the fact of state funding of certain interstate things like the highway system can be used as a cudgel to coerce states into this is a problem. We're seeing this right now in a unique circumstance where President Trump is trying to coerce the governor of Colorado to pardon a ally of President Trump. I think her name is Tina Peters, who is convicted under state law, which means Trump himself cannot pardon her. Only the governor can. The question of whether to pardon someone convicted under state law is supposed to be purely at the discretion of a state governor. It's not something that the federal government, let alone the president himself, should be getting involved with. But again, there are so many things you can threaten a particular state with withholding if they don't do what you want them to do. So those are all absolutely federalism concerns. When it comes to private entities like universities, as libertarians, we're not a fan of them being funded at all. But if the government is going to get into the business of funding them, the two key things I would look at are equal protection clause. Are they all being treated equally? Or is it the same deal or the same neutral rules for who gets what? And then individual rights. Another way to phrase it is unconstitutional conditions doctrine. Are any of them being given these benefits or being threatened with withholding these benefits on condition that they give up some core constitutional rights, whether that's the right to speak freely or anything else? And too often it seems like they're being coerced to give up their speech rights.
I want to come back to non-delegation because I am a big fan of the non-delegation doctrine, and I would join you in that semi-lonely fight to instate it or reinstate it. Basically, for folks who don't know, that's essentially the idea that Congress can't just give agencies open-ended authority to make major policy decisions. But then when I think about Congress is very polarized, extremely undercapacitated. It's been really for several generations almost at this point. And oftentimes they write legislation that's deliberately vague because that may be the only way they can get anything to pass in the first place. And so I'm a fan of the non-delegation doctrine in theory. But then when I think, well, what happens if the courts demanded a level of that kind of level of legislative specificity that honestly, I think Congress, as it is currently constituted, is simply not capable of producing. So how do you wrestle with that, what I think is a pretty important tension?
It is. It's a great question, and it's one that we get a lot, and it's one we think about a lot. So one answer is that it's a little bit of a chicken or the egg problem, which is what should we wait for first? Should we wait for Congress to up its capacity and become good at legislating again, and only then reinstate the non-delegation doctrine? Or vice versa, should we reinstate the non-delegation doctrine and hope that that will force Congress to be more muscular, kind of like throwing a toddler into the pool who doesn't know how to swim yet? Do you just hope that, they'll suddenly learn if they have to? Necessity being the mother of invention or something like that. So that's one answer, is that maybe if, we had a shock to the system and a vague piece of legislation were struck down, maybe that would change the incentives for who wants to serve in Congress. Right now, you can serve in Congress with basically nothing but a comms team without any legislative policy staff. Maybe that might no longer be true if suddenly it's an all-hands-on-deck situation of we need to write a lot more laws. So I think we underestimate the ability of Congress to maybe relearn that muscle memory that has atrophied over the past decades, as you've said. The other answer, though, is that my view of the proper role of Congress and of how to comply with a properly enforced non-delegation doctrine is that Congress has to be the one that goes on record and votes up or down for every policy decision. That does not mean every single sentence of every piece of legislation has to be written by staffers for Congress. So there's a creative proposal called the REINS Act, which is just the most prominent example of others like it, that basically says we can have the same administrative state we have now, where, bureaucrats in an agency propose a rule, it goes through revisions, finally gets an up or down, yes or no from a higher level person in that agency. The only difference is under the current system, once the agency signs off on it, it becomes a rule and it has the force of law. Just add one more step at the end, which is a yes or no vote in the House and the Senate with no amendments and no filibusters. And if it is approved by the House and the Senate and signed by the president, it's a law, it's a statute, not a regulation. And the benefit of that, the reason that that's constitutionally compliant, is accountability. You are forcing every member to vote yes or no on that. And something only becomes a law if a majority of the House and the Senate and the president are willing to put their names on it. And that's not true of regulations right now. So even if you have no faith in the current Congress to write policy at the level of detail and wonkiness that bureaucrats in HHS are writing policy, that doesn't mean you can't still have statutes at that level of detail. You just walk over the regulation from the HHS building to the Capitol as the last step.
Okay. We can't have, we're nearing the end of our conversation, but we cannot have a conversation about the Supreme Court. I think it might actually be a law, I don't know, without talking about the emergency docket or the shadow docket right now. Now, to me, I feel like this is an incredibly overblown sort of moral panic sort of thing in a way, but maybe I'm wrong about that. I want to get your take on why you think so many people are so worked up in recent years about the shadow docket, and is it as big of a deal as some people make it out to be in your view?
Well, it's certainly become a lot more active in the last maybe 10 years, roughly since the first Trump administration, certainly since the recent Biden administration. And I think there's a fairly fair book by Steve Vladeck called The Shadow Docket that kind of walks through this history and why this is. A lot of it, though, is connected to what we've discussed, which is the president's using executive authority in a much more muscular way, in a much faster way, trying to enact policies that are real shocks to the system. And again, we can point to policies from presidents of both parties, whether it's the student loan forgiveness or the nationwide eviction moratorium from President Biden, or the birthright citizenship order, or the tariffs order from President Trump. There are certain instances of actions where people want to know, is this a law? What the heck's going on? And especially now that we pretty clearly, unless there's a class action, which is hard to do, now that we know that a single district court judge generally can't block a policy nationwide, there might be instances where you think, wow, if this is just blatantly unconstitutional, do we really want to let the administration get away with it for like a year, which is how long it typically takes to get up to the Supreme Court and get a decision on the merits? So the emergency docket is an opportunity for the Supreme Court to block something much quicker. There's certainly, I think it's absolutely true that the Supreme Court does not do its best work on the shadow docket in terms of reasoning or explanations or having time to really think through the correct answers to things. From my perspective, there's generally no time for amicus briefs. Sometimes they won't even accept them. The briefs are shorter, they're quicker, they're filed in the span of maybe a week or two instead of multiple months. There's no oral argument, and sometimes there's no opinion at all, or if there is, it's a couple of pages. So you don't want that to be the law. And I think there is a legitimate critique that it shouldn't be treated as precedent binding on lower courts in the same way that a fully reasoned opinion on the merits after oral argument is precedent binding on the lower courts. But there is, all that being said, given that there are some blatantly unconstitutional actions or blatantly illegal actions, I don't want to get rid of the emergency docket entirely. I want there to be that backstop of ultimately, sometimes it's better for the status quo to be something that the political branches don't want it to be as a case is being litigated. And the only court that can do that nationwide is the Supreme Court.
And so you can argue that the essential elimination of nationwide injunctions by, say, district court judge actually makes the shadow docket even more important in that sense.
Exactly, right. That, if there's going to be an answer for the whole country while a case is pending, I think you would rather have that come from the Supreme Court than a district court. And Justice Kavanaugh has a concurrence in one of these cases kind of defending the shadow or the interim docket on these grounds that I encourage readers to read.
Now, I always like to end interviews, if I can, on at least a somewhat optimistic note. And so when you think about the state of the court, the presidency, our institutions in general, what do you see that gives you kind of a genuine cause for, optimism about American constitutionalism right now?
Sure. Well, I think, as I mentioned, this conventional wisdom took root falsely last year that the Supreme Court was letting the Trump administration walk right over it. That I don't know exactly, that Trump had won something like 18 out of 19 emergency petitions to the Supreme Court. But if you looked at them, they were all on very specific niche questions of venue or standing or timing. And the Trump administration was very intentionally picking its battles. They were only appealing the cases where they thought they could win on these more technical issues. Now, in 2026, we're getting cases up to the Supreme Court on the merits for the first time. The tariffs case, the birthright citizenship case about ending temporary protected status. And we've seen Trump already lose on tariffs. I'm very confident he's going to lose on birthright citizenship. It seems based on oral argument, it's a genuine toss-up whether he's going to lose on temporary protected status in terms of immigrants from war-torn countries. And so this is not a court that just because 6 justices were appointed by Republicans is going to uphold the actions of a Republican president. And if you read the tariffs case, it's a very thorough and by the book, a statutory interpretation decision that I think plays it completely straight. So as much as people critique the justices or call them, ensconced or protected or out of touch, this is a great example where life tenure and a salary protection really matters because doesn't matter that Trump hired them, he can't fire them. And I was at the birthright citizenship oral argument with Trump sitting in the stands about 30 feet from me, glowering at the justices, but it doesn't matter. He's not their boss. So I didn't have, how unique is it that we have a system where the head of the executive branch can come into court and he just has to sit there like anyone else and watch quietly. He can't do anything to change the outcome.
All right. Well, on that note, we will close. Thomas Berry, thank you so much for taking the time to talk with me today.
Thank you. It was a great conversation. Really appreciate it.
Thanks for listening to this Politics Guys interview. If you have a question or comment for us, we'd love to hear from you. You can reach us at mail@politicsguys.com. If you're not already a supporter of the show, we hope you'll consider becoming one. Supporters get ad-free versions of everything we release, our full-length midweek episode instead of just a preview, and access to our Politics Guys Discord group. It's a fun place with a great bunch of people. You can support us on Patreon, where you can even sign up for a free trial. And if Patreon isn't your thing, or you're a current supporter and want to give us a little extra one-shot contribution, you can support us on PayPal and Venmo too. You'll find links to all our support options at politicsguys.com/support and in the show notes. If you'd like to get our full-length midweek episodes, but you're not in a position to financially support the podcast right now, just email me. I'm at mike@politicsguys.com, and I will be happy to get that set up for you. And whether you're a supporter or not, we'd appreciate it if you could subscribe, rate, and review us on whatever podcast app you use, as well as sharing episodes on social media. And finally, a very special thanks to our wonderful executive producers. They are Wilma Moreno, Daniel Toe, Ryan Beasley, Don Oglesby, Derek Schmidt, Dakota Heath, Jason Chrysler, Dave Dean, Jeremy Larson, Brian Matza, and Jody Marie Miller.
This podcast is part of the Democracy Group.